Hello, everyone, and welcome to another episode of Talking Law. This time, we've got a very exciting episode. It's going to be short, sharp, just like our last one, and it's going to be focused on those buyers in off the plan contracts. Specifically, I'm titling it The 7 Most Common Mistakes Made by Buyers When Entering an Off the Plan Contract. Priala Legal is a specialised boutique property law firm, and we focus very much predominantly on off the plan contracts. Now, over the years, more than 20 years, we've acted for developers and we've established and gone to assist developers over the years finish a number of projects, and that's been very rewarding and exciting, and we continue to do that today. We also act for buyers in pretty much most of the projects in Southeast Queensland, and acting for developers over the years has given us a unique perspective, in my opinion and my view, to then be able to advise buyers on the other end of the spectrum in off the plan contracts and projects. And as we've seen, particularly on the Gold Coast and in Brisbane, the landscape for off the plan contracts has changed dramatically in the last 2 years, really since COVID began. And that was really the trigger point for this massive property market upswing that we've had in Southeast Queensland. So what I want to do today is explain, which I think is very interesting and exciting and very informative for buyers, what are the 7 most common mistakes that buyers make? So let's get into it. So number one, 100%, you might even guess what it is. Buyers do not get pre-contract advice before they sign that off the plan contract. Now, that's title I've just mentioned, the first common mistake. Buyers don't get pre-contract advice. And that's going to cover a few things. That's going to mean they don't see anybody before they sign that off the plan contract. So they don't have the opportunity to get that pre-contract advice, which is really critical. Or they do see someone, but that someone is not an experienced property lawyer in off the plan. And or they see the third person, or another person, I should say, who is not a lawyer at all. So perhaps a paralegal or a conveyancer that might have assisted them with previous property transactions, but those transactions maybe they've assisted the buyer with or you with were not off the plan. So make no mistake that off the plan is a very complex area of law. When you're viewing off the plan contracts, and we actually prepare them for developers, so when we view these contracts for buyers in other projects, we have to at least understand fundamentally at least 3 pieces of legislation in Queensland, and those pieces of legislation in Queensland are intricate, they're complex, and they're changing. And some of them have gone through already recent changes in the last 12 months in Queensland, and some of them are under review by state government at the moment to continue to have change in this area of law. So only lawyers and those lawyers who practice in off the plan very much so will have their finger on the pulse like we do at Priala Legal to then be able to advise buyers properly before they sign a contract. And every buyer is different. So when we talk to buyers, we very much explain to them about the terms and conditions of the contract, the pros and cons, positive, negatives. We never advise clients whether they should or should not buy a particular property off the plan. That's not our decision to make. It's up to the buyer. We want to inform buyers. That is our role. Our job is to give buyers that critical information upfront to allow them to make an informed decision. And each buyer has a different risk assessment based on their own background, their financial capability, whether they've entered into off the plan contracts before, and their expectations, which often after we give that pre-contract advice is very different to what they originally thought. So getting pre-contract advice from someone who is qualified in this area of law. And that is a common mistake made even today after numerous headlines have hit the paper about various controversial issues in off the plan contracts. So understanding fundamentally what you're getting into from day one is critical before you even sign that contract. So that's number one, common mistake. We don't want buyers to make that mistake. So number 2, the balance deposit. Now, it may seem like something simple, but it's actually not, because part of our risk assessment when we talk to buyers is we ask the critical question. Now, your balance deposit of the 10% deposit, because typically you pay 10% in off the plan contract. So your balance 10% deposit is payable in, could be 7 days from the contract date, could be 14 days typically. And the question we ask buyers is, well, do you have those funds? And you might find this surprising to know that when I ask that question, some buyers say, oh, actually, I don't have that money. It's either tied up in a term deposit, or I didn't realize I had to have it straight away. Can't I pay it later? So that's some of the comments that some buyers have given me, and I very much tell them up front. The condition to pay a balance deposit is an essential term. It's critical that you have the funds available and that you will be able to pay that when the time comes. And also for them to understand, if you don't pay that balance deposit, then you will be in breach of that contract very early on, which is not really great at all. And whatever you've paid as the initial holding deposit can be taken by the developer. So buyers do not want to be in that position at all, where they can be in a breach situation with a developer up front. You want to understand that it is a 10% deposit, that you do have to pay it by the due date. And if you don't, yes, it's a default. The developer can terminate that contract. You will lose the lot that you might have been negotiating for a number of weeks. And that's not an ideal position at all to be in. So that is part of the buyer's financial capability of entering into an off the plan. Now, there are some options out there for buyers that aren't cashed up with a 10% deposit, not necessarily first-time buyers I'm talking about, sometimes investors who are asset rich, cash poor, who do not have 10% cash sitting around to be used on and off the plan deposit. So there are other options out there. Coposit is a great company that's formed in Sydney that has been on some projects in Queensland, predominantly in New South Wales. It offers an option for buyers. There are also other options such as a deposit bond or a bank guarantee. So there's always options, and this is why we mention it up front. We talk to buyers up front in that critical pre-contract advice meeting about how do you intend to pay your balance deposit. So very important, but make no mistake here, you do have to pay it by the due date. It is an essential term. Okay, common mistake number 3, and none of these are really in any particular order. Just so when you're listening to this, you're aware of that. I haven't placed them in an order of priority. They're all equally important as far as I'm concerned with that. So just bear that in mind. So number 3, a lot of buyers go into an off the plan thinking that if they change their mind through the construction period, being the contract period that you're under, that you can just on sell it to someone else. Happy days, hunky dory, I'm out of the contract. Now that is not the case at all. If you are being a speculative buyer, number one, if you're going in, oh, well, I'll just go into it, I'll probably be able to on-sell it, make a profit. Look, that is potentially doable, but you need to understand what that means. And every contract is different about on-selling and about getting the developer's consent, what that process looks like. If there are any specific conditions in that off-the-plan contract that the developer makes you adhere to, requires you to adhere to, you need to know what that looks like up front so you have the right expectations. So that's speculative buyers. Equally so, though, with buyers that just change their mind. Something unforeseen happens in their life during the construction period and they really can't settle or don't want to settle anymore. So this conversation we have up front with buyers flushes out a lot of things, such as my advice to buyers that when you sign an off-the-plan contract, I call it locked-in Eddie. So like the game show. So when you sign that off the plan contract, you are locked in till the end, till completion. And that may very well be the entire sunset date period, which in Queensland there is a maximum of 5.5 years. But you always go to your contract to see what the sunset date period is in your particular contract. But it can be up to a maximum of 5.5 years in Queensland for body corporates off the plan. So very, very important to understand, well, during the construction period, your contract period, whilst you're under contract, if you want to on-sell generally, and it's always subject to the contract, you have to get the developer's consent. And if you get the developer's consent, you then sell to a third-party buyer over here. You never actually, well, you don't get out of your contract. That's the common mistake made here by buyers, that if I on-sell, I actually get out of my contract. You don't. Typically, you are actually still committed into your original contract over here with the developer, and you have your contract over here with your third-party buyer. And these two contracts stay on foot all the way through to completion. And then when you get to completion, the idea is that your third-party buyer is the party that settles with the developer instead of you. And only at that point do you get to bow out. Up until that point, you're still liable to settle with the developer on your original contract, and you pay duty on that original contract. And that's another discussion perhaps for another time. But make no mistake that by on-selling, it doesn't mean you actually get out of your contract. So very important to understand that process and what's stipulated in your off-the-plan contract. Common mistake number 4, I can't negotiate the terms of the off-the-plan contract with the developer. Now, that's incorrect, particularly since we've seen the changes to the unfair contract terms regime that kicked in November last year, with substantial penalties now going to those parties who do not offer any opportunity to negotiate an off-the-plan contract. Now, that doesn't mean that every off-the-plan contract contains numerous unfair terms. And it also doesn't mean that as a buyer that you get to ask for all and sundry. What you ask for in a negotiation phase must be things that are fair and reasonable. And only an experienced property lawyer in this area of law can actually help you understand what is fair and reasonable in terms of the scheme of an off-the-plan contract. And it's very much dependent on what does that off-the-plan contract look like from the outset, from the get-go. So you can negotiate. Sometimes the negotiations, you might seem that you would negotiate and get a lot, sometimes not. And that does depend on what is already in your contract. Some developers and their lawyers, understandably so, take the view that if they give you one aspect in a contract as a win, then you won't get other things as equally as a win. So it's like a trade-off. For example, if they give you 100% of the interest earned on the deposit, it's a cash deposit, of course, then you won't get land tax adjustment removed at settlement. So that is sometimes seen as an offset, and that can be seen as a fair interplay, if you will, between a developer and a buyer, balancing out the competing interests between the two. But yes, you can actually negotiate. You can ask for things. If you don't ask, you don't get. That's very much the case. But you also have to be, as a buyer, fair and reasonable, as does a developer. So common mistake number 5, going through and signing an off-the-plan contract, or really understanding an off-the-plan contract, and the entire process is easy peasy. It's actually not. As I said before, this is a complex area of law. At least 3 pieces of Queensland legislation are brought into off-the-plan contracts, and the person that you're getting advice from needs to understand how all of that works and what's in the pipeline for law reform in Queensland. And there are quite a few things in the pipeline for off-the-plan contracts. So it's understanding that the law is complex. It is not easy peasy. It is not something for a junior. It is not something, in my opinion, for a conveyancer or a paralegal to give advice. They can't. They're not lawyers, and they shouldn't be giving legal advice anyway. It is a complex area of law. You're usually dealing with a contract that's 70 to 80 pages. And all of the provisions are relevant for you to understand what that means for you as a buyer. So very much it's a common mistake. That's why some people don't get that advice. And when you think about it, you're investing, whether it's an investment property or going to be your primary residence, suffice to say, for the purposes of what I'm saying, you are investing into a property. In this market, you can't really get anything under 800,000 in the off-the-plan space. So when you think of investing a value of a property from anywhere from 800,000 to 5-6 million, you're putting your 10% deposit down. You're investing a lot of your money and your time and waiting around for this project to be completed. So you want to pay a fair fee upfront for a really good advice to be given to you from a qualified property lawyer, it really is a no-brainer as far as I'm concerned. Common mistake number 6. Developer is not entitled to alter anything in that original contract. Now, that is not the case. So acting for developers in Queensland, and it's like this with other states, developers do take on an enormous amount of risk at all different levels when they do projects. Equally so, buyers take their own risks in entering into an off-the-plan contract. So there are risks all around in this transaction. So because of that, developers must have flexibility to a large degree, and flexibility in terms of changing things if they need to. Now, we're not saying that developers from the get-go market a particular project in a particular way, but really intend to give something different and deliver something different. That's not what I'm saying. What I'm saying is that sometimes or often there are unforeseen events that occur. There are unforeseen requirements from council or from other third parties that then require the developer to change certain aspects along the way during the construction period that they couldn't foresee from the beginning, such as there might be extra infrastructure, extra concreting, extra columns that might, for example, increase or decrease the square meterage of that lot, that unit that you're wanting to buy. Now, it can happen in any project. No project or developer is sort of removed from that because of the unknowns and the unforeseens in projects generally. So there can be variations. What you need to understand is get that pre-contract advice. It's critical to understand how the law works in this area of law and to understand about what we call the 5% tolerance rule, which is a rule that's been seen through the courts in many, many instances in Queensland, Victoria, and New South Wales. And what does it mean? What's the 5% tolerance rule? What does that look like for you as a buyer upfront? And understanding within the scheme of things if there is a material or immaterial change, and then understanding what your rights are under the legislations that I talked about before. But also, what does the contract say? Maybe the contract gives you additional rights or obligations. Maybe it doesn't. So it's really important to understand that, yes, changes can occur, variations can occur. And when does a developer have to tell you? That's important to know that they don't have to tell you straight away. They can tell you at the end, as long as you're given that 21-day period to review, which you are, because it's built into the legislation. So you can see that there are a myriad of issues here at law that you need to understand. And why do you need to understand this up front? Because as I'm going through and explaining to you, there are lots of common mistakes, and perhaps we could call them misconceptions, that buyers have when they enter into an off-the-plan contract. So it's about informing the buyers, this is the landscape and how it works. If you like it, great, let's sign up. If you don't like it and you realize this is not for you, for example, I don't want to wait 2, 3, 4, 5 years. I thought that I could change my mind and get out of a contract halfway through, which is not the case. So once you understand that landscape and you go, yep, this is for me, big green tick, great, let's do it. I'm happy because you've understood as a buyer and you're well informed, you've got your eyes wide open, as I call it, and I tell all my buyers that. But if you don't have that information and you don't have that knowledge and your eyes are sort of shut because no one's giving you that critical advice, then you go into an off-the-plan contract with the wrong expectations, which can then have a flow-on effect and can cause problems for you in your personal life, financially, and with the developer. So we don't want that. Okay, so the last common mistake is this, that in Queensland, time is of the essence in all property contracts. The REIQ contracts have it, and they've always had it. Off-the-plan contracts have it as well. So we act for a number of buyers around Australia, in all of the states and territories. We act for buyers overseas, in many, many different countries. And it is something I tell every buyer, time is of the essence. What does that even mean? So then we have another conversation. It means this, and it's all centered around the timing of your obligations, from paying that balance deposit I talked about before to settlement. Settlement's a real critical one for obvious reasons. So when we say time is of the essence, a common mistake or misconception that buyers have is, well, if I can't settle on the settlement date, the developer will just give me an extension. No, absolutely not. We know that developers are entitled to have buyers settle on the settlement date, very much so. Buyers who get themselves into a situation where they're not ready, unfortunately, or their funder banks are not ready for settlement, that's very unfortunate. But make no mistake, it is time of the essence. You must settle on the settlement date. That is critical. So we know this, and we tell buyers this all the time, and we get buyers ready in advance. And that's the other advantage of using someone like us, because we understand how projects work, and we understand that time is critical and essential, and that you have to settle. And we start telling buyers at least 2-3 months out of what looks like practical completion. Look, these are all the things you need to do to be ready for your settlement. We give them a checklist, and we make sure that they understand that. And why is that? Because the timing in Queensland is, and there are many steps the developer has to do to get to the point where they can call for settlement. But let's go through a lot of those hoops. So once they get through to practical completion, they have to have a certificate of occupation or classification issued. They have to get council to seal that plan. You have to lodge that plan for registration with Queensland Titles. Now, once that plan is registered, it comes out of Queensland Titles. We get told that same day, but the settlement date is only typically 14 days from when the plan registers to when settlement occurs. It's a very short window. It goes through very quick, or goes by very quick. We have to do a lot of things in the 14 days. You have to do a lot of things in the 14 days. So if you have done absolutely nothing to get yourself ready by the time that plan registers and we get told, and then settlements in 14 days, you will not be in a very good position. So you have to be ready early, whether that means selling a property on the market early, getting that money in, whether you have to get a loan, start talking to the banks early, 3-4 months out of practical completion. So these are all the things we talk to buyers in that pre-contract advice meeting. And that's about the risk assessment we give to buyers as well, about asking them, how do you intend to fund the purchase of this at settlement? And then that conversation comes out about whether it's a loan, whether it's I've got to sell my property, having them understand, of course, that, well, you can never time the settlement of your property to move into an off the plan perfectly. You just can't, because nobody knows when settlement's going to be for an off the plan. At the beginning, of course, you don't know, but leading up to settlement to practical completion, nobody knows the exact date. It's very difficult to time that. So the point being, can't just assume the developer will be sympathetic and empathetic and give you an extension. Absolutely not. You have to be ready and be ready to settle. Otherwise, it's a default, and the developer can take you 10% deposit. And you don't want to be in that position. The developer can also sue you for damages, can sue you for the deficiency in a resale of that lot. So if you can't settle, the lot then gets resold at a lower price. There's a deficiency in that price because the developer couldn't sell it for the price that he sold it to you for. Then you will be up for that deficiency if he decides to sue you. And that doesn't look or bode very well for you as a buyer naturally. So you don't ever want to be in a default position. So the point being is, do not assume the developer will give you an extension. If he ends up giving you an extension because you do actually need it, great, but you will find that extension will come with conditions such as default interest and legal costs typically. And some of them do give it those extensions. The other thing I do want to say is, with the changes to the unfair contract terms regime in November last year, we have been seeing some off the plan contracts give a built-in extension right of 5 business days as well, similar to the REIQ contract. So we've seen that come through, but not all off the plan contracts have it. So that is why you need to be ready and not assume that the developer will give you that extension if you need it. So hopefully you've got a lot of valuable information from this as buyers, the 7 most common mistakes made and misconceptions, if I can also call it that. And if you have any queries or inquiries or would love us to act for you in any of the plan contract, come and see us before you sign that contract, which is absolutely critical. And we're happy to explain the process to you and how it works from the get-go. Thanks, everyone. And we'll see you soon on the next episode of Talking Law.